Good afternoon, everyone, and thank you for joining us. My name is Amelia Ramsey, and I'm the Confiscations and Proceeds of Crime Partner at Dugan George Lawyers. Welcome, and thank you for joining us in this last week before the break. I'm sure it's been a busy week for everyone, so it's wonderful to have you all join us. This is our third webinar and the last one for 2024, but there will be more next year. We'll be kicking off again in February. Remember that you can watch the recorded webinars on our website just by searching Dugan George Webinars. For our third webinar, I would like to introduce again our speaker, Christian Juebner of King's Counsel. Christian took silk in 2022, and whilst he principally has a commercial litigation practice, he's also known as an expert in proceeds of crime litigation. He's a member of the Confiscation and Proceeds of Crime list users groups of the Supreme Court of Victoria and County Court of Victoria. Today, Christian is going to talk to us about steps that can be taken by clients to protect their property from forfeiture. Christian, over to you.
Thank you, Amelia, and good afternoon, everybody. Thanks for joining us at probably what's a busy time of year, but I hope it'll be worthwhile. I'm going to try and present a practical discussion or explanation of the steps that should be taken by practitioners who are acting for persons who've had their property restrained so as to seek to achieve the best prospects of having it unrestrained in due course. In terms of the structure of what I'm going to discuss, firstly, I'm going to discuss the relevant applications that can be made, then the statutory tests for those applications, that's exclusion applications and compensation applications in particular. Then I want to address the statutory test for forfeiture, where no conviction of serious offences arises. Then I want to say something about preparing evidence and some practical guidance in how evidence should be prepared, principally the affidavits in support of the applications for exclusion or compensation. And lastly, I'm going to mention something about examinations, given that the Commissioner has to be afforded the reasonable opportunity to conduct examinations before any application for exclusion is heard and determined. All right, in terms of applications, it's of course important that practitioners file the right application. And there are broadly three types of applications that can be filed to protect property. The first is an exclusion application. I'll address those in more detail shortly because there are various different types of exclusion applications. An exclusion application is an application where if it succeeds, you get the actual property back. So it's an in specie return of property. The second is a compensation application. A compensation application is an application to be paid an amount of money which is part of the proceeds of sale of the forfeited property, depending on the proportion to which one can show that the forfeited property was derived from lawful sources. The third type of application, it's not often seen and sometimes overlooked, is a hardship relief order application, which can be made where a dependent suffers particular hardship arising from forfeiture. First now, let's turn to the exclusion applications. They're the most common, and most people who work in this space will be familiar broadly with them. And there are different types of exclusion applications, and it's important that you file the right type of application. The first exclusion application is an exclusion application to exclude property from the restraining order. And that's either made under Section 30 or 31 of the Act. If notice of the application for the restraining order is given, which is rare, but sometimes it is, and it is given in circumstances where there's been a seizure and the assets are already safeguarded, usually by the AFP having seized the goods, such as cash or cars, then the application for exclusion from the restraining order must be made before the restraining order is in fact made. And that's often overlooked by practitioners. If you don't do it before the restraining order is made, you have to seek leave to be permitted to make an application for exclusion. So you want to avoid that. But the most common situation is where the restraining order is made ex parte, your clients are served, and only after that time do you then make the application for exclusion, that application is made under section 31. In each case, the exclusion test, which I'll explain shortly, is the test in section 29. That's for exclusion from restraining order. The second type of exclusion applications are exclusion applications from prospective or actual forfeiture orders. So as opposed to restraining orders, exclusion from forfeiture orders. That's usually the case when there are no pending charges. So it's a pure civil forfeiture regime. An application for exclusion from a prospective forfeiture order is made under section 73, and there's something you must be very careful about, and it's this. In order to, in the absence of a conviction, in order for the AFP to obtain a forfeiture order, they must either satisfy the test in section 47 or section 49. Section 47 correlates with the section 18 restraining order, and section 49 correlates with the section 19 restraining order. Sometimes restraining orders are made under both bases, that's section 18 and 19. If your client is served with a restraining order that includes a section 19 restraining order that has property restrained, and you only make an application for exclusion under section 73, and that application for some reason fails, the Commissioner is relieved of his obligation to prove the property is either proceeds or an instrument, unless you have also made an application for exclusion under sections 30 or 31 to exclude the property from the restraining order. And it is something often overlooked, and it arises by the operation of section 49.3. So be very careful about that. In short, the safest type of application for exclusion to make, to cover all bases, is to make the application to exclude property from the restraining order. The third type of exclusion application that can be made is in circumstances where an accused or a suspect has been convicted of a serious offence. In that instance, all of the restrained property is liable to automatic forfeiture within 6 months of the date of conviction, unless it's excluded either from the restraining order under the section 29 test, that's the exclusion application from restraining order, or you make a new application for exclusion under section 94, and that is the method by which you can exclude property that is otherwise going to be automatically forfeited. And I talked previously in one of the earlier seminars that you can see on Duke George's website, or also on confiscation.com.au website, in relation to the various timeframes for making these applications. But if there's one lesson in all of this, unless your client is convicted of a serious offence, I would at least also make an application for exclusion under either section 30 or 31 to have it determined under section 29. That way you cover all bases. The second type of application, as I mentioned earlier, is a compensation application. Now, the purpose of a compensation application is to prevent the all or nothing outcome of an exclusion application. And I'll talk a bit more about the all or nothing outcome, but because of the exclusion test, if you don't satisfy the test, and it's, to be fair, it's a difficult test to satisfy, but if you don't satisfy it, you won't get an exclusion order. The consequence is, depending on whether there are or are not convictions, property may well be automatically forfeited. But the compensation application seeks to ameliorate against the harsh consequences of automatic forfeiture, because it allows the court to make an order that a proportion of the value of the applicant's interest, which was not derived or realised directly or indirectly from the commission of any offence, be paid back to the applicant. It's also a requirement that the relevant property is not an instrument. But take this example. A property is purchased for $1 million. $200,000 of that $1 million purchase price is derived from drug trafficking, $800,000 from an inheritance. It's just a really simplistic example. So 20% clearly ill-gotten gains used to acquire the property, 80% lawful. 5 years later, the property is worth $2 million, and for some reason it becomes restrained. Under a compensation order, the applicant would expect or could expect to have the property forfeited because they will not be able to show that the property is not proceeds, because at least part of the property was derived through unlawful activity. But they could expect to, upon sale, to receive a cheque for about $1.6 million, be 80% of the then market value of the property of $2 million. That's how, in broad terms, a compensation order works. And they're made under Section 77, and they can also be made under Section 94A, where a person has been convicted of a serious offence. Now, I mentioned earlier briefly the hardship application that applies only to a dependent. A dependent, in circumstances where forfeiture would cause what's described as hardship. But the cases, whilst the Act talks about hardship, the cases clearly establish that there's an ordinary level of hardship that is to be expected to arise under the proceeds of crime forfeiture regime, and it's more than that you need to show in order to get up on a hardship application. You've got to show, some judges have described it as undue hardship, but you've got to show something extra, because otherwise it would render the Act in one sense nugatory if every time there was hardship arising from ordinary forfeiture there was an ability to obtain relief. But these types of provisions, or the hardship provision in particular, is significant if, for example, the family home is about to be forfeited. And I mean, I've had a number of clients in these situations. You've got a father, husband who's been charged, who's about to go to prison, sometimes for a long period of time, a wife and children who've had nothing to do with any of the offending, who are about to lose the family home and be rendered homeless. Now, in those sorts of scenarios, you'd have to give careful consideration to making a hardship application, and the loss of the family home, particularly if one was otherwise rendered homeless, in circumstances where previously there was support from the husband who's about to go to jail, financial support, that would be a good basis for a hardship application. Now, let's talk now about the statutory test for exclusion. There are two limbs in a nutshell. You must show, when I say you must show, the applicant for exclusion bears the onus of proof to demonstrate these things on the civil standard, that is, on the balance of probabilities. Two things. Firstly, that the property sought to be excluded is not proceeds. That's the defined term, proceeds. It's a key concept under the Act, of unlawful activity. And secondly, that the interest is not an instrument, that's the other defined term, of a serious offence. Now, the definitions of proceeds and instrument are found in section 329, but they quite often raise interesting questions, maybe best explained by way of examples. Assume for a moment that someone has $10,000 in their bank account, and we talk about money in the bank account, but in a legal sense, all that is a debt owed by the bank to the account holder. It's a chosen action. It's a debt. Say that $10,000 has been derived as to $9,000 from wages and $1,000 from fraud. So you've got 90% of the balance staying to the credit of the account from lawful sources, 10% from illegal sources. Would that mean the money in the account, and again I use that colloquial expression, is proceeds? Was the amount, is the account wholly derived or realised? No, but is it partly derived or realised from the commission of an offence? And the answer to that would almost certainly be yes. The High Court, in a case called Hart, examined this test, and the plurality said this about it: property would not answer the description of being partly derived from an act or omission if the degree of derivation were no more than trivial. So they use the expression trivial. Beyond that, however, there is no requirement that the degree of derivation must be substantial, and there is no requirement that the degree of derivation must be proportionate to the forfeiture that has occurred. So in short, unless you can show that what's in the account, or the call it unlawful contribution to the account, is trivial or de minimis, as Justice Gordon described it, it's going to be an instrument. And when 10% of the account balance in this relevant example is from fraud, then clearly it's proceeds. The whole lot is tainted as proceeds. That raises various interesting questions, some of which have not yet been determined. For example, the tracing of monies through bank accounts in the context of this legislation. Take this example. You've got a $50,000 account balance from wages, $10,000 deposit in the account also from drug trafficking. So you've got a $60,000 account balance. And the money from the wages was in the account first. And thereafter there was the deposit of $10,000. On the decision of Hart, you would have to say that what's in the credit balance in the account is proceeds. But on a first in, first out analysis, if you then buy a car for $40,000, on a first in, first out analysis, that is deemed to have been purchased with funds that come from the wages. And after you bought that car, there's $20,000 left in the account, $10,000 left over from wages, and then the second $10,000 from the drug trafficking. So based on the rule in Clayton's case, if that was the analysis, you would say the car wasn't proceeds. Also, interesting issues arise in the context of tax. And I have to say, in more recent years, tax, both income tax, excise taxes, have become far more litigated in this under the Proceeds of Crime Act. But in a case that's often been quoted called DPP and Jeffrey, Chief Justice Hunt was considering whether or not property was relevantly an instrument or used in or derived from the commission of tax offences. In that particular case, the relevant accused or Mr. Jeffrey had been convicted, in fact, of failing to lodge tax returns deliberately. And the court said this: the applicant had the use of funds whilst available to him which would have been payable if he had not committed the offence over the years, and property acquired with those funds would, in my view, have been derived indirectly from the commission of those offences in accordance with the reasoning in Saffron's case. So in short, if your clients commit a tax offence, and as a result of that have money in their hands with which they then acquire property, then there's every reason to think that that property is regarded as proceeds of crime. And that is so, as Chief Justice Hunt mentioned, notwithstanding that the tax was subsequently paid. So in that case, Mr. Jeffrey ultimately did pay the tax, but he delayed it for many, many years, during which he acquired a large number of assets. So whilst initially it might sound quite simplistic, that is something derived or realised directly or indirectly from the commission of the offence, or partly so, in practice, there's often questions of degree. The same thing arises in the context of the instruments. That is, whether something has been used in or in connection with the commission of an offence. I mean, the classic simple case that sadly we see all too often are meth labs and cannabis houses, and there's no doubt at all that those houses are used in or in connection with the commission of the offence. Often there are electricity bypasses and plumbing and all sorts of things, so that the house is clearly an instrument. Likewise, although not as obvious, loan applications made to banks where property is proffered as security in circumstances where the banks are deceived, that is, obtaining financial advantage by deception, with a mortgage placed over a particular property to give rise to the advance from the bank, that house is almost certainly an instrument because it was used in or in connection with the commission of the offence. Then at the other end of the spectrum, there are cases not so much under the Proceeds of Crime Act, but certainly under the Confiscation Act, which has similar themes. For example, the sexual assault cases. The case of Ghana was one where a houseboat was specifically fitted out to attract kids to play there where they were assaulted, and the court found that that houseboat was more than the location of the commission of the offence. It was used in or in connection with the commission of the offence. Similarly, in the case of Richardson, where a farm was found to be used in or in connection with the commission of sexual assaults on young boys. And you can compare the case of DPP and King, for example, where a young girl was assaulted on a yacht as it was sailing up the New South Wales coast. And the question was the yacht used in connection with that offence? And the court came to the conclusion, maybe somewhat surprisingly I have to say, that the yacht wasn't used in connection with that offence. It just happened to be the place where the offence occurred, so the court found. The High Court considered this issue in a case called White, where there was a murder in a bikie compound in WA, and found that because the bikie compound had a fence around it, and the victim was seeking to climb the fence to escape the compound when he was shot, that the property was used in or in connection with the commission of the murder. But there are also other cases where properties have been found simply to be the location of the murder rather than being used in connection with. So it's very fact dependent. That's the short point of it, which eventually means that you need to pay close attention to the evidence that you put forward in support of your exclusion applications, because it is fact dependent. There's one more particular section that you need to be aware of. It's section 330 subsection 4A, nicely hidden away in the Proceeds of Crime Act. It's important for this reason. Once something is proceeds or an instrument under the Proceeds of Crime Act, it remains with those characteristics until such time as section 330 subsection 4A is satisfied. That is, proceeds remains proceeds even when converted from one type of asset into another until you get to satisfy that particular section. Now, what that section says is that something ceases to be proceeds of an offence or an instrument of an offence if it is acquired by a third party for sufficient consideration without the third party knowing and in circumstances that would not arouse a reasonable suspicion that the property was proceeds of an offence or an instrument of an offence. Now, I draw that to your attention because when you're drafting affidavits, you'll probably have to address that test in some of your applications. Take this example. I go to a teller machine downstairs in the bottom of my building in Chambers, and I pull out $50. That $50 note might have been used last week or the week before in a drug transaction, unbeknownst to me. But because of section 330 subsection 4A, when I take that $50 note and put it in my wallet, it's no longer proceeds or an instrument of crime because I'm a third party who's given sufficient consideration because the bank has debited my account without knowing and without grounds to suspect that that particular $50 note that comes out of the ATM machine has been used in the drug transaction. So that's how, call it, innocent people are protected when dealing with property in circumstances where they don't know and have no reasonable grounds to suspect that they might be dealing with something that otherwise would be proceeds or an instrument. Now, that particular test went to the High Court in the cases of Laudianto and Kelamuthu, who were heard together only a few years ago, involving what's called cuckoo smurfing. And I'll just quickly digress and just explain what happened in those cases. In short, in both of those cases, you had overseas persons who wanted to bring funds to Australia. And because in some countries from where people bring funds to Australia, there are exchange controls and there are various ways of seeking to overcome or get around them, they go to a local money remitter and they give genuinely hard-earned money to a money remitter in return for a promise that the money remitter will ensure the money is, they say, transferred into your account. That is what occurred, and I, in fact, acted for a number of other applicants in a similar situation. We just managed to resolve our applications rather than run them all the way through. But in short, the money remitters in those cuckoo smurfing cases are linked with criminal syndicates who then have somebody from the syndicate collect the cash in the various overseas jurisdictions, whether it be China, Vietnam, Indonesia, Iran, and various other locations from which I've seen this sort of conduct occur. The money remitter gets a small commission, and the criminal syndicate takes custody of the cash, which was legitimately earned by the client. In return, a whole lot of cash, which is built up in Australia, usually from illicit activities such as drug trafficking, gets deposited into the customer's account, usually in cash and usually in transactions just under $10,000 to seek to avoid the reporting obligations that banks have through AUSTRAC. And within a few days, the $1 million that was been handed over in real or dong or whatever currency it might be has found its way into a bank account in Australia through cash deposits. And the question arose in those two cases whether or not the persons who had given up their hard-earned money in a foreign jurisdiction were persons who satisfied that test, that is, whether they provided sufficient consideration without knowing and in circumstances that would not arouse a reasonable suspicion that the property, that is what's now in their accounts, was proceeds of an offence. And in short, it was dealt with at first instance, then on appeal, then in the High Court. There are that many different judgments all the way through the three levels of our judiciary. But by majority of the High Court, it was found that the individuals had provided sufficient consideration by giving the money to the money remitters. In almost all instances, it was found that they didn't know that the money that they were receiving would be proceeds of crime, but it was found that the objective element of the test, that is, that a reasonable person in their position would have formed a suspicion about it, and therefore they were lost everything that they had deposited with the money remitter overseas. So it's a harsh result, particularly when AUSTRAC on its website publishes the fact that cuckoo smurfing deprives innocent victims of property. But that's what the High Court found, that is, that the objective element of the test wasn't satisfied. Now, the statutory test for compensation, I think I mentioned it before, that is that you need to satisfy the court that a proportion of the value of the applicant's interest wasn't derived or realised directly or indirectly from the commission of the offence. And the court must be satisfied that the interest is not an instrument of the offence. But it's a second best option, because with a compensation order, you only get money back from part of the proceeds of sale of the property. You don't salvage the actual property. I want to say something now about the statutory test for forfeiture that the Commissioner must establish where there is no conviction of a serious offence. That is, under the Proceeds of Crime Act, you can have a situation of automatic forfeiture, but that can only occur in circumstances where there's a conviction of the suspect of a serious offence. Where that doesn't happen, the Commissioner can still get forfeiture, but the Commissioner then ultimately bears the onus of satisfying the court that a forfeiture order should be made and has to satisfy the forfeiture tests in section 47 if it's a section 18 restraining order, or section 49 if it's a section 19 restraining order. What's important to remember is that if you're going to oppose an application for forfeiture, you have to give notice of the grounds of opposition. Now, that's enshrined in both the Supreme Court Criminal Procedure Rules, which is sort of confusingly described because this is civil litigation, but for some reason it's dealt with in the Supreme Court Criminal Procedure Rules, or in the County Court Miscellaneous Rules. Relevantly, Rule 10.11 of the County Court Miscellaneous Rules provides that a person who intends to oppose an application has to give notice of the grounds. That applies equally, of course, to the Commissioner when the Commissioner seeks to oppose applications for exclusion or compensation orders. And I'll say something more about that because that's a pretty important issue. Now, if the Commissioner wants to get a forfeiture order under Section 47 to forfeit property that's restrained under a Section 18 restraining order, I've said I don't want to be boring about it, but it's important to remember that Section 18 restraining order corresponds with Section 47. Section 19 restraining order corresponds with Section 49. But if the Commissioner wants to get a Section 47 restraining order, a forfeiture order, I beg your pardon, in substance, what must be shown is that the court must be satisfied that the person whose conduct or suspected conduct formed the basis of the restraining order engaged in the conduct, constituting one or more serious offences. So let's just break that down. The Commissioner must establish that a criminal offence was committed on the civil standard, and the civil standard being the balance of probabilities, but using the old language, employing the Briginshaw test, which is now enshrined in Section 140 of the Evidence Act. So the court has to have a high level of satisfaction before it would find that there would be that someone has committed such an offence. And importantly, even if there is an acquittal, someone is charged and acquitted, the Proceeds of Crime Act makes clear that even after an acquittal, the Commissioner can establish on the civil standard that the offence was committed and seek forfeiture. And that has occurred. There's a case called Safadi where that occurred. I think there are one or two other examples of it. Now, the Section 49 test is this, that if the Commissioner wants to seek forfeiture of property restrained under a Section 19 order, then the Commissioner must show on the balance of probabilities that the property is either proceeds of one or more indictable offences or an instrument of a serious offence. Now, I mentioned before that the circumstance that the Commissioner is relieved of the obligation to show that if no application for exclusion is pending under to exclude property from the restraining order. And that's a trap for young players, to be honest. You have to have that application on foot, failing which the Commissioner will not need to show that. The Commissioner will then simply obtain the forfeiture order on the basis of showing the restraining order has been in place for 6 months and that everyone who might have an interest in the property has been given notice. So it's effectively almost automatic forfeiture without any conviction, so it's dangerous. I'm now going to turn to another topic, that's issues in preparing evidence. Firstly, if I can say one thing practical to you, start collating the documents early. The evidence has to be by way of affidavit. Affidavits need exhibits. The exhibits ultimately tell the story because they're the contemporaneous documents. And in the modern world, most of the financial transactions are well recorded through bank accounts or the PEXA transfer system, various other electronic means. So start collecting documents early for lots of reasons. Firstly, bank statements and so forth. Banks only keep, or generally keep, their documents for about 6 years. After that, if you want documents going back further, you may well not get them. So if you have a delay in seeking documents, you may ultimately find you don't get as many as you need to prove the things you need to prove, bearing in mind your clients will have the onus on exclusion applications. In respect of property transactions, obtain the contracts of sale, obtain the settlement statement, obtain the statement of adjustments, and bear in mind that conveyancers and solicitors don't keep their files forever either. In many cases, they're destroyed after about 7 years. Get copies of the tax returns, get copies of the tax assessment notices, get copies of financial statements for family companies or trusts, get copies of trust deeds. All of that's going to be easier, particularly if you're acting for someone who might go into custody, to do all this while they're still out in the community. Secondly, as I've said, the evidence is by way of affidavits. Think about who your witnesses are going to be, and be mindful of the Jones and Dunkhill inference that can be drawn if you don't call witnesses who you would be expected to call. So think about who it is that you need to prove the various things you need to prove as part of the exclusion test. Then it's important to give consideration to how far you have to go in an affidavit to establish something. And I've seen all ends of the spectrum. I've seen half-page affidavits where someone simply deposes to the fact that something is not an instrument, something is not proceeds. That's not good enough. And I've seen affidavits that run into tens and tens of pages, mostly filled with irrelevant material, and go way overboard. There is a happy balance to be struck. The important issue is this. The cases, and I'll mention a couple of them in a moment, say that you only need to deal in your evidence with issues that have been expressly or inferentially raised by the Commissioner. In DPP and Jeffrey, again, Chief Justice Hunt said this: as a matter of practical reality, what an applicant for an exclusion order must do in most cases in order to establish the negative facts is not only to deny on oath in general terms that the property was so used in or derived from any such unlawful activity, but also to establish what activities it was in fact used in and derived from. However, in my view, it is not necessary for the applicant, in addition to his sworn denial in general terms that the property had been so used in any unlawful activities, to deal specifically with every kind of unlawful activity which could be imagined in relation to the use of such property. Therefore, the applicant, in addition to his sworn denial in general terms that the property had been used in any unlawful activities, need deal specifically only with inferences available from the evidence that his property had been used in a particular unlawful activity and which tend to contradict his sworn denial. Now, that's a long quote, but it's recently, in the case of Laudianto and Kalamutu, which I mentioned before, the Kukusmurtin cases, the High Court refined all this and said this, quoting from Hart, "It is proof in an adversarial proceeding conducted in accordance with the civil procedure of that court, including such procedure as exists in that court for the definition of issues between parties. Where an application for orders under Section 102 proceeds on pleadings, an applicant need not negative possibilities which the Commonwealth does not raise in its defence." Now, there are not strictly pleadings, of course, in proceeds of crime cases as they're presently being run in Victoria, and I'm not suggesting there should be pleadings. There were pleadings in this particular case in Queensland that found its way to the High Court. But there are mechanisms, important mechanisms in Victoria to ensure that the issues to be disputed are clearly identified. And that must occur before the evidence is closed. And that occurs through the notice that I mentioned before, the notice of grounds of contest, which takes, in one sense, the role of what otherwise in a civil proceeding would be a pleading. They need to identify with precision the basis for the opposition. And I have to say, over the last few years, there's been a much greater appreciation of the need and the importance of the grounds of opposition. And if you're obtaining directions for the filing of evidence, you should ensure that those directions include, amongst other things, an order that the Commissioner file a notice of grounds of opposition, or it's now called a notice of grounds of contest, prior to putting on any reply evidence to the Commissioner's evidence, so you get a chance to deal with any issues that specifically arise. And I've seen various notices of grounds of opposition that the Commissioner has proffered, which are manifestly inadequate because they seek to reserve their right to raise further issues in the course of the hearing, and that simply can't be accepted. And I have to say, there's been pushback against that sort of attempt to retain any room to swerve at a trial. If, of course, issues arise at trial, any party can make application to seek to amend their grounds on which they seek to run or oppose an application, in the same way as one at trial can make an application to amend pleadings. That's then assessed at the time by reference to all the facts and circumstances. But it is important. I can't overestimate the importance of the notice of grounds of opposition. And can I say one more thing before I leave the topic of affidavits? I've seen sometimes the style of an affidavit that refers back to the affidavit in support of the application for the restraining order and takes issue with various aspects of it. For example, I refer to paragraph 15 of agent whatever's affidavit, and I say ABC about it. That's a really bad drafting style for this reason. The affidavits in support of the application for a restraining order are almost wholly inadmissible at the final trial because they're premised on a different evidentiary standard. They're premised on reasonable grounds to suspect something occurred as opposed to proof on the balance of probabilities. But if you start drafting affidavits by reference to the paragraphs in an affidavit that's otherwise inadmissible, you may well make it admissible in circumstances where that won't be very helpful to your clients. So that's a bad practice. Don't do it. The last thing I want to touch on are examinations. I mentioned earlier that the Commissioner has to be afforded a reasonable opportunity to conduct examinations under the Proceeds of Crime Act before any application for exclusion is heard and determined. A reasonable opportunity doesn't mean an absolute right, and there are instances where the Commissioner has delayed in seeking examinations, and in circumstances where that would have an examination would have pushed back a trial date, an examination order has been refused. But on the whole, courts are very receptive to the Commissioner's application for examination, and I have to say rightly so. That's a right, an entrenched right under the Act to have the opportunity. There's been a significant increase in examinations since the decision in Zhang some years ago. Before that, they were sparingly used. Examinations are draconian affairs. They are conducted in private, that is, before an examiner who was a presidential member of the AAT in Victoria and New South Wales as well. Relevantly, they occur in circumstances where all privileges are abrogated. That is, the self-incrimination privilege is abrogated. The counterbalancing right is the direct use immunity that applies to any answers. That is, any answers given by an examinee can't be used directly against them in any criminal prosecution, but indirect use is permitted. Also, legal professional privilege is abrogated. That then leads to this. It's important, and actually I'll come to this in a minute. I want to talk about quarantine orders, but before I do so, I want to say something else about the examination notices. Firstly, an examination order, when it's made, defines the scope of the examination. That is, an examination about the affairs of somebody or particular property, whatever it might be. But it's important that you pay close attention to the scope of the examination as ordered by the court, particularly if you're appearing for the examinee at the examination, because there may be a basis for objecting when questions range beyond that which is the permitted scope. Secondly, examination notices, which is the notice you receive from the examiner to attend, will commonly include a request for the production of a lot of documents. Now, there's nothing inappropriate about that. The Act expressly permits the examination notice to make reference to documents to be produced, but the breadth or manner of description of the documents has, in some instances, been incredibly broad and imprecise. And as a result, we've taken issue on a number of occasions with the breadth of the examination order document production obligations and have managed to pare those back. It's important to understand, of course, that the non-compliance with an examination order is punishable by imprisonment. So that's why it's critical that it's clearly expressed, particularly in terms of the document requested. Now, coming back to the quarantine order. Section 266 capital A of the Proceeds of Crime Act creates a default position that enables the Commissioner to share information coercively acquired, including through the examination process with other various law enforcement agencies. In circumstances where, if your client were charged with particular offences and then was to be examined about matters, that would give rise to a real concern that that transcript of the examination or documents produced in response to an examination notice might then be shared with other law enforcement authorities. The way to overcome that concern is to seek an order be made under Section 266 capital A, quarantining the coercively acquired information through the examination process to ensure that it does not, that it's used only for the purpose of the Proceeds of Crime Act litigation rather than any other purpose to which it would otherwise be potentially directed. And in that context, one thing to note is that, and this was decided recently in the case of Yang, that the quarantine order can only protect against self-incrimination, as the word says. You can't protect against incriminating somebody else. That is, if you've got two co-accused, strictly speaking, each co-accused can get a quarantine order to protect the use of the material in their own prosecution, but not in each other's prosecutions. Now, one final matter to observe about examinations is this. Usually when an examination, the first examination, comes to an end, particularly if it involved the production of documents, it's the Commissioner's practice to seek to adjourn the examination to a date to be fixed. And that's unobjectionable because the Commissioner will want to look at the material that's been produced and decide whether or not to conduct a further examine the particular examinee. What I would do, and what I do in each instance, is to ensure that you get an order from the examiner that unless the Commissioner calls back the examination within a certain period of time, the examination is deemed at an end. Otherwise, you're in this limbo situation where the examination, it sort of endures indefinitely. You don't want that. So to create some certainty, I would suggest that you get such an order. And that's all I was going to say today. I think 10 to 6, we're close to Christmas. There's really only one thing left for me to say, and that's that I wish everybody on this a safe and happy festive season, and look forward to seeing you in the new year.
I echo that. Thanks, Christian. Thanks very much for today. And thank you, everyone, for joining us. We will see you again in the new year in February. Keep an eye on our social media for the topic and for the date of that in February. We'll see you then. Thank you.